Hello, everyone. For folks joining, we'll get started in about a minute. Hello, everyone. For the folks joining, we'll get started in about 30 seconds from now. Good afternoon, and welcome to ELI's 6th session of summer school this year, Climate Change and Environmental Law. My name is Madison Calhoun. I'm the Senior Manager of Educational Programs at the Environmental Law Institute. Each summer, ELI convenes a complimentary seminar series that offers an introduction into the legal and policy foundations of environmental protection in the United States. The series is aimed at folks who do not already have a background in environmental law. It's an introductory course into the basics and the foundational elements of environmental law. We're getting to the tail end of our summer school series. We just have 2 sessions left after this one. Environmental justice is taking place next Thursday and will be held via live Zoom webinar. After that, we'll have 1 more session of summer school this year that will be hosted at our Washington, D.C. office, which is Hazardous Waste and Sites, which will be 2 weeks from today. All sessions will be recorded and posted to ELI's website within a few business days of each event. It'll also be posted to our YouTube page. If you have missed any previous sessions that took place earlier this summer, we encourage you to check them out now via our website or again, ELI's YouTube page. You can find each individual session on our website at eli.org. Please reach out to me or events@eli.org with any questions whatsoever. Now we'll go ahead and kick things off for today's session. Today's session is exciting because it is a brand new topic in our summer school series, Climate Change and Environmental Law. We've received many requests to add on a session on climate change during summer school, so we decided this year was a great and important year to try this out. We have an absolutely stellar panel for you today, so I want to thank our speakers for being here. In a moment, I will hand things over to our wonderful moderator. She'll give some opening remarks, and then our 3 panelists will each give short presentations. After their presentations, we'll have a roundtable discussion, followed by time to answer audience questions. Please feel free to submit your questions as you think of them using Zoom's Q&A function. There's no need to wait until the end of the program. You can submit your questions as soon as you think of them. The chat function is also open. We encourage you to use this to converse with one another or to post your observations throughout the event. However, please remember to put your questions in the Q&A box, not in the chat, if you would like our panelists to address them. With that, let's begin. I'm going to now introduce our moderator, Lisa. Lisa Ann Hambleton is an attorney with over 20 years of combined experience in U.S. securities law and climate law and policy. She's currently the Climate Finance Policy Director for the Chisholm Legacy Project, where she leads federal regulatory engagement and just transition initiatives for frontline communities. Prior to joining TCLP, she held positions with the Georgetown Climate Center in Washington, D.C. as the Adaptation Program Director and with the Center for International Environmental Law as the Director of the Climate and Energy Program. In addition to her professional responsibilities, she serves as a member of the Steering Committee for the Environment, Energy, and Natural Resources Community for the DC Bar. Over to you, Lisa. Thank you so much for being here.
And thank you, Madison, for that wonderful introduction. And thank you for having me. So welcome, everybody. We are really in for a treat today because it is very unusual that you get to have such three esteemed leaders in the legal profession, period, but who are such experts in the area of climate change. So just to repeat that brief housekeeping note that Madison mentioned, please put your questions in the Q&A. Don't wait till the end. We'll be tracking them and following them. Madison's going to help make sure those questions get answered. So just to get started, to give a little bit of context here, I'm delighted that you all are here and that there is such interest in understanding the ways in which climate law is changing our understanding of law, rights, and responsibilities. And look, we're now seeing different ways in which states are responding into the US. In the US, we're looking at federal policy, tremendous efforts under the Biden-Harris administration to address climate action. We are looking at ways in which we're at a new stage of cooperation as far as the global framework on mitigating climate impacts, as well as providing the funding for adaptation measures. So with all of those developments, it's changing our understanding of rights and responsibilities. So we are so lucky to have three experts who are helping to navigate the landscape of these developments. We're going to be hearing from perspectives on the science of climate change, really understanding the relationship between the work of the IPCC, our understanding of changes in global temperatures, what impact that has globally, and the ways in which our ways to measure those impacts are becoming increasingly accurate and more reliable. We're going to discuss the ways in which those data and metrics are helping us to better understand the foreseeability of climate harms. As I mentioned, we're also going to take a brief overview of the global frameworks. You'll hear about the UNFCCC, its founding, the commitments that over 190 countries participated and ratified under the Paris Agreement, and that will help us better understand what are the rights and responsibilities and terms like common but differentiated responsibilities under those agreements. Our speakers will also provide us a little bit of insight into some of the legal arguments that we're seeing in both judicial and quasi-judicial forums. We're going to be talking a little bit about legal concepts like public nuisance to be able to better understand the ways in which climate change is impacting our understanding of the rights and responsibilities of parties in protecting the environment, as well as the ways in which the responsibilities connected to environmental degradation. We're going to be talking about the efforts of state and local governments and their relationships to federal governments in addressing the challenges of climate change. And then we might be, I believe we're going to be addressing a little bit some of the changes in our understanding of corporate responsibilities, not only among the executives, their board of directors, and their shareholders as well, in the ways in which climate change is being addressed at every level of decision making. So without further ado, I'm just going to briefly introduce each of our speakers. And I'm trying to, I have to confess, we did not fully decide whether I'm going to run through each of the speaker introductions or whether I'm going to give them, I think I'm going to give them a chance to give their presentations. And when they've completed them, I will introduce the next speakers. So our first speaker, Professor Michael Gerrard. He is the founder and faculty director of the Sabin Center for Climate Change Law at Columbia University School of Law. He is one of the foremost environmental lawyers in the nation, and I'm going to say globally, because I think Michael is also particularly humble, but he has been an extraordinary advocate, litigator, teacher, and scholar who has provided both the tools and perspectives to address climate change and inform the global debate on climate change law, energy regulation, and has helped really expand the academic environment for understanding developments. And I do encourage you all at the end of this discussion to please look at the Sabin Center resources, as well as the resources of all of our colleagues, because if there are questions that you have, chances are they have both the legal and factual documents too that go deeper into any of the topics we discussed today. So without further ado, Professor Michael Gerrard.
Thank you for that very kind introduction, Lisa. And I'm going to see if I can now take control of the screen. And what I'm going to be doing is I'll start by talking about what are the sources of greenhouse gas emissions, where are they coming from, what are the trends that we're seeing, what are the potential impacts, and then I'll talk about the international framework for the climate change control. So first, the sources of greenhouse gases in the world: 14.3 gigatons of carbon dioxide come annually from China. China is by far the leading emitter today. The United States is a distant second, India is third, and so on down the list. So even though China is the leading emitter today, that's a fairly recent phenomenon. The US for many years was the leading emitter of greenhouse gases. China overtook us around 2007 with its explosive economic growth. And you can see that that India has been moving up in terms of its total emissions. The European Union has been moving down. What really has the impacts today are the cumulative emissions. Carbon dioxide, which is the principal greenhouse gas, can stay in the atmosphere for more than a century. And so the climate impacts we are experiencing today are a result of not only the emissions that have occurred in the past year, but over more than a century. And as you can see from this chart, the US is by far the leading source of the carbon dioxide emissions that are now in the atmosphere and that are causing the impacts that we're now experiencing. China is a second. They're catching up. In some decades they'll exceed us, but it's still the US as the number one source. Per capita emissions are another way to look at this. And as you can see, the US of the countries listed here has by far the largest per capita emissions. We are rivaled only by Canada, Australia, and Saudi Arabia. US per capita emissions have been declining for some years, mostly because of the conversion of a lot of power plants from coal to natural gas, also because of the growth of renewables, greater energy efficiency measures, including of motor vehicles, and the offshoring of some industry. But US per capita emissions have gone down. The per capita emissions of China have gone up very considerably, but they're still about only half of those of the US. An additional way to think about it is what are the per capita, what are the percentage of CO2 emissions by wealth by the people in the world. And what we see here is that the richest 10% of the people in the world are responsible for about half of the greenhouse gas emissions in the world. And the poorest half are responsible for only about 10%. Another factor is that these numbers about emissions are only about where are the emissions happening? What are the emissions from the factories and so forth where goods are being made? But a lot of the goods that we consume in the United States and that are consumed in Europe and Japan and so forth are made elsewhere, especially in China. And so the emissions attributable to the production of goods in China that are used here are in China's ledger under this calculation. So total fossil greenhouse gas emissions have been going up. As you can see, they've been rising steadily. The only times that they have declined have been in times of severe financial crisis. So the first and second oil crises of the 70s, the dissolution of the Soviet Union, and the collapse of those economies, the global financial crisis, all led to very temporary downturns in greenhouse gas emissions, and the onset of the COVID pandemic led to a significant downturn, but it bounced up, and we're now at higher levels than ever before. Because emissions have been going up, so have levels of carbon dioxide in the atmosphere. As I said, the emissions, their impact is cumulative. There's an observatory in Hawaii that sort of measures the baseline. It goes up and down every year. The reason for that is that in the winter, a lot of vegetation dies and releases its CO2 into the atmosphere. In the summer, when plants grow, they absorb CO2. So that's why you have this bud variation every year, but the trend is going up and up and up. Even though it's a global average, there's a lot more land surface in the northern hemisphere rather than the southern hemisphere. So the fact that you have different alternating winters and summers, the northern hemisphere governs. Because the levels of greenhouse gases in the atmosphere have been going up, so have the temperatures. So these are global average temperatures going back to 1850. As you can see, they bounce up and down, but the trend is unmistakable. And the 8 warmest years in recorded history are the 8 most recent years. This year, we're seeing extraordinary increases in temperature. What this chart shows, each of these little lines is a year, and you see what are the global mean surface temperatures across the year in each of these years. This was the heavy black line is the mean for the period 79 to 2000, and 2003 is warmer than it's ever been. In fact, the warmest years in recorded history were last week, July 3rd, 4th, and 5th. And this chart is a little old already, and there are some more recent years that are that high. We also see went back too far. Trying to go backwards, but I'm going forward.
Michael, if you hit the left arrow key on your keyboard, it will go backwards for you.
There we go. Thank you. Okay, this is where I was. Now, a continuation of the trends we've been seeing in temperature would take us to about 1.5 degrees centigrade in 2034 and 2 degrees in 2060. In a couple of minutes, I'll talk about the significance of those figures. And now, actually, the trends drawn from this line do not reflect what we've seen in the last few years, and so the trends may actually be accelerating. But in any event, in the prior trends, this is where the temperatures are taking us. It is not only the atmosphere that is warming, it's also the oceans. And in fact, the oceans retain much more heat and much more carbon dioxide than the atmosphere. And we can see that the level of heat in the upper 2,000 meters of the atmosphere keeps on going up as well. I'm sorry, of the oceans keeps on going up as well. And the surface of the sea is even hotter. And this is a chart similar to what I showed a couple of minutes ago, but this is the annual levels of temperature in these various years across the course of a year. And the sea surface temperatures are now far higher than they have this year, are far higher than they have been in recorded history. This is a source of a great deal of concern. One of the reasons for the concern is that heat in the sea surface adds to the intensity of hurricanes, and the hurricane season is shortly going to begin, so we'll see what happens. Antarctic sea ice is also an indicator of what's happening. And we see that in 2023, there's an extraordinary decline in Antarctic sea ice. So things are not good. In terms of what the future may bring, various projections of global average temperatures under different greenhouse gas emission scenarios. It now looks like we may be heading toward about 3 degrees C by the end of the century. A lot of models seem to suggest that, or maybe a little lower. That's the scenario, and you can see the tremendous increase in global average temperatures. And when there is an increase in global average temperatures, it also means that the extremes are that much further along. There are different scenarios for future sea level rise, depending on mostly on the level of greenhouse gas emissions and on the behavior of the Antarctic and Greenland ice sheets. A lot of uncertainty about what those will be, but under high greenhouse gas scenarios, by the end of the century, we may have future sea levels of about 2.5 meters higher than they are now, although it's not the same everywhere in the world. Some places it'll be higher, some places it'll be lower. One of the most severe consequences of extreme climate events is forced displacement. People need to leave their homes because of sea level rise, drought, flooding, other climate-related phenomenon. A couple of years ago, the World Bank issued a report projecting that by 2050, unless there are significant reductions in greenhouse gas emissions, about 216 million people in these continents would be forced to leave. Now, not all of them would migrate to would try to migrate to other countries, but they would be forced to leave. Just to put this in perspective, the Syrian civil war displaced around 7 million people and went a long way toward destabilizing the politics of Europe. Here we're looking at potential displacement far higher than that, and that's just 2050. So the way the international community has been trying to deal with all of this, the international agreement that has actually had the greatest impact on climate change was not overtly a climate change agreement. It was the Montreal Protocol on ozone depleting substances, which led to which was a major success in leading to the decline in the use of chlorofluorocarbons and various other chemicals that were degrading the ozone layer. Most of those chemicals are also very serious greenhouse gases. And so the Montreal Protocol and its subsequent amendments, including the Kigali Amendment, have been very, very successful in lowering global warming. The Intergovernmental Panel on Climate Change, the IPCC, was formed in 1988, a time when scientists were raising loud alarms about climate change. And in 1992, at a conference in Rio, the UN Framework Convention on Climate Change was negotiated. It was signed by President George W. Bush, by President George H.W. Bush, and it was ratified by acclamation by the United States Senate. The Framework Convention on Climate Change set the objective of preventing dangerous anthropogenic interference with the climate system, but it didn't define what level of temperature that meant and how that would be achieved. It did set up a structure where there would be an annual conference of the parties, a COP, where the countries would all get together and decide what to do next. So coming up with the mechanics of how to achieve the objective was left to the annual meeting, annual conference of the parties that was held in Kyoto, Japan in 1997. In the lead up to that conference, it became clear that the structure that was emerging was that the major developed countries would have an obligation to reduce their greenhouse gas emissions, but the major developing countries would not. So China and India and so forth would not be obligated to reduce their greenhouse gas emissions. They were still trying to have their large populations emerge from deep poverty, and they wouldn't have those obligations. That did not sit well with the United States Senate. And shortly before the Kyoto meeting, the Senate passed by a vote of 95-0, something called the Byrd-Hagel resolution, which said the U.S. should not sign on to any international agreement that did not require the major developing countries such as China and India to reduce their greenhouse gas emissions. So the Kyoto Protocol was negotiated. Vice President Al Gore led the U.S. Delegation, but President Clinton didn't submit the Kyoto Protocol to the Senate for ratification because he knew it wouldn't pass. The U.S. became the only major country not to sign on to the Kyoto Protocol. The Kyoto Protocol ultimately imposed emission reduction obligations on only a fraction of global emissions, since the U.S. didn't sign on. China and India and the other developing countries didn't have emission reduction obligations. Canada dropped out. But there were a couple of lasting programs to come out of the Kyoto Protocol. One of them was called the Clean Development Mechanism, which was basically a scheme under which the developed countries could pay developing countries to reduce their emissions and take credit for it. The theory of it is that it would also help the development of the poorest countries, but the way it turned out is the great bulk of the projects were in China and India, and to a lesser extent, Brazil, all of them countries with sophisticated bureaucracies that were able to handle the extraordinarily complicated paperwork of the Clean Development Mechanism. Very little in Africa and in parts of Asia and Latin America was really needed. The Kyoto Protocol also helped set up a global emissions trading system. Europe established its own emission trading system, and we now see that in many parts of the world there are either carbon taxes or emission trading systems. But it became clear that the Kyoto Protocol really wasn't working and something new would be necessary. The hopes were that that would be achieved in a conference of the parties in Copenhagen in 2009. That basically failed. There was an inability to reach a new agreement. They tried again in Paris in 2015, and that did succeed in getting a global agreement. So it was seen as a great triumph when it was accomplished. Here, this is Christiana Fogueras, who was the head of the UN Environment Program, Ban Ki-moon, the Secretary General of the United Nations, Laurent Fabius, the Foreign Minister of France, who chaired the conference, and Francois Hollande, the President of France. The basic structure of the Paris Agreement is that each country would submit what was called a nationally determined contribution, an NDC, which would be its non-binding, unenforceable pledge for how much it was going to reduce greenhouse gas emissions. Virtually every country in the world signed on to this and submitted their nationally determined contributions. The Copenhagen Agreement had said that the goal of reducing greenhouse gases was reducing global average temperatures was 2 degrees centigrade, 3.7 degrees Fahrenheit. But the small island states vigorously objected, saying that that was too hot, that at 2 degrees they would be underwater. They wanted a 1.5 degree goal. So the Paris Agreement also asked the IPCC to come up with a report on what it would look like at 1.5 versus 2 degrees. This report was issued in 2018. It showed that we really need to stay within 1.5 degrees, if at all possible, because the impacts at 2 degrees would be terrible. Where we are now, this is from a report that the IPCC released in March, and it goes out to 2100. These are the actual global emissions. This is where the NDCs would take us. Most of the NDCs just go out to 2030. But if they're all carried out, this is where they would take us. The policies that are actually being implemented, if they continue and are not strengthened, would take us out to here to around 3.2 degrees Celsius. Now, there's a very broad uncertainty range about exactly what the policies will accomplish and so forth, but the middle of that range is 3.2 degrees. If we were on a pathway to stay at 2 degrees Celsius, we would be down here, and 1.5 degrees, we would be down here. So under any calculation, we are way off the path of being at the 1.5 degrees where we, according to the IPCC, we need to be. The US, and Carrie is going to talk more about this in a minute, this is what the actual emissions have been on the left, and toward the right you can see the upper what business as usual would have taken us to, where the Inflation Reduction Act takes us, and then the Paris target in 2030 set by President Biden, which is a 50 to 52% reduction in greenhouse gas emissions by 2030, showing there's a lot left to be done, and much of that would be left to the states and the private sector. This is just a 50% reduction. By 2050, we need to be down to about zero, net zero, to meet the Paris climate goal. So there's a lot more to be done. The Paris Agreement does set out a mechanism to try to improve. Everybody recognized in Paris in 2015 that the nationally determined contributions didn't go high enough. So there's a mechanism to try to increase ambition to get us to where we need to be. So far, the ambition has increased a little bit, but not nearly to where we need to be. One NGO, the Climate Action Tracker, has rated the country's climate policies according to whether they're compatible with 1.5 degrees. As we can see, the countries that are rated here as almost sufficient, only 2 of them are major developed countries, Norway and the UK. Many countries are rated as insufficient, including the US. During the Trump administration, they were ranked by this group as highly insufficient, and we can see a lot of countries are critically insufficient. So there is a great deal more work to be done. Finally, another pledge that was made in Copenhagen and reiterated in Paris is that the major developed countries would contribute by 2020 at least $100 billion annually to the developing countries to help them prepare for climate change and reduce their emissions. But that amount has not been met, and we now know that the needs are far higher than that. So my last slide in this part, this is global greenhouse gas concentrations in the atmosphere. Going back to 1960, the stripes denote temperatures. Redder is warmer. And we have these UN climate meetings that have taken place, but the climate doesn't care. It's not the effect of all of this on the climate is not discernible. It may be that the numbers would be worse without them, but clearly we are not going in a direction we need to. So with that, I will turn it back to Lisa for introduce the next speaker.
Fantastic. Fantastic. Thank you so much, Michael. That's extremely informative overview of not only the contributions to climate change, the history of the UN framework, but also where we are and where we stand. I think most of us saw the AP announcement that went under the wire in a lot of ways that we had reached 1.5 degrees with already logging some of the hottest days recorded in history. So helping us understand that overview and science is incredibly helpful. And I just want to say thank you all for continuing to add those questions in the Q&A. We will have the Q&A portion after each of our speakers complete their discussion. So please keep them coming. They are being noted and recorded. So I am ready to introduce our next speaker, Carrie Jenks, who is the Executive Director for the Harvard Law School Environmental and Energy Law Program, where her advocacy and resources provide the legal research and analysis to not only acknowledge and recognize environmental degradation, but to allow communities to inform and facilitate a just transition to a low carbon economy. Prior to joining ELP, Carrie was vice president at Emmett J. Bradley and Associates, where she directed power company coalitions, as well as prior to that, a legal career at two very prominent law firms. She received, and so I'm going to also encourage you all to take a look at the more detailed bios in the announcement for this particular event. And again, encourage you to review the resources on their websites for additional information about the topics and information that they are providing today. So without further ado, Carrie Jenks.
Great, thanks so much. So thanks so much for having me today. I see if this just works. There we go. Okay. So just a little bit of background on Harvard's program, the Environmental and Energy Law Program, or EELP. So as Lisa mentioned, we are a research arm at the law school. We are a team of 7 attorneys, and we look to identify solutions to regulatory hurdles to the clean energy transition and regulatory solutions that could accelerate that transition. In the end, I think it's critical to identify solutions so that the regulations stick, meaning that they can be implemented, enforced, and upheld by courts. And as I'll talk about, that's tricky, given all the different players and the dynamics that the 3 of us will talk about today. I put some of the resources there. We do a tracker. We try to explain some of these regulations, and then we've got podcasts. So welcome you to take a look at all of that. I'll start with some background. It's picking up where Michael left off. The US being one of the largest emitters, I think it's important to understand what are the sources of emissions in the US. So this graphic is from EPA. And right now, the transportation sector is the largest source of emissions, closely followed by the power sector and the industrial sector. I think it's important to recognize the customer demand for products that are coming for this to show how complex the problems are, as well as the fact that there's many different subsectors in these sectors. So if you think about the industrial sector, for example, there's cement, there's steel, there's other industrial processes, and the technologies, the cost considerations, and the different emission opportunities are all different within that sector. And some components of the sectors are easier to decarbonize than others. So I think that's important to keep in mind, just to understand why it's so challenging. There's also 3 different ways we can think about carbon policy. So adaptation is the process to adapt to the actual expected climate effects. If you think about some of the effects that Michael was talking about, what are the policies that can help communities adapt to that? Mitigation is what I'll talk about more, is what is a human intervention to reduce emissions or enhance the sinks of greenhouse gases. And the resilience is the capacity of social, economic, and environmental systems to cope with the hazards and the events that we're seeing. So I think there's policies that are needed on all 3. I'll focus mainly on the middle one. So I'm going to start with some real basic background, but I think it's important to think about what are the levers and policies for climate policy. So the US Constitution divides us into 3 branches of government. You've got the legislative branch, the White House, an executive branch, and the judicial branch. The legislative branch is the US House and Senate, and that's where the rules sort of get made that then the executive branch has the policy priorities to implement. And I'll talk about one bill that passed last summer by Congress that's really setting the stage for climate policy going forward. Then the executive branch, that's the White House and the federal agencies that implement and enforce the laws. And I'll spend some time about the different agencies and really the breadth of agencies in the Biden administration that's working on climate policy. But a thing to keep in mind is that federal agencies, most of them conduct rulemakings, meaning they often are required to propose a rule, take public comment on that rule, and then finalize the rule. The inherent nature of that is regulatory development is slow, it's deliberate, it's made to be slow and deliberate so that you can build that expertise for each rule. That's also sometimes frustrating in how long it takes. But then once that rule is final, then it can go to the courts. And in the courts, we've got the district courts, courts of appeals, and the US Supreme Court. And I know we'll spend some time, and Vicki will talk through some of the key cases that are really shaping what's happening on the ground. But to summarize, this process is designed to create checks and balances on the government power, meaning there's a lot of different players, but it's also a lot of different steps to get climate policy across the finish line. So a few background slides to just explain what are the tools that these agencies have to address climate policy. So carbon pricing is one tool. It's a market-based mechanism for lowering warming emissions, greenhouse gases. And the aim is to put a price on an actual emission, an actual monetary value, so that the price signal gets sent to create shifts in consumption and investment decisions, making economic development more compatible with climate policy. So the simplest one, the easiest one to understand, is a carbon tax. And therefore, if you have 1 ton of CO2 being emitted, you can put a price. So for every ton, you pay a price. And that's essentially the carbon tax. There's a lot of different political dynamics with implementing that. You don't have the emission certainty necessary to know what we'll get, but assuming that the economy responds to that price, you could see lower emission reductions depending on how it's designed. The other one is more of a cap and trade or cap and invest program, whereby a government policymaker could determine what is the cap of emissions that we want to hit. Some entities would be above that emission, some would be below, but they could also have a crediting system whereby the one that's above the cap could buy a credit from an entity that was below the credit before that cap. The government could also say every ton you emit, you have to buy a credit from us, and then you can emit that ton. And so that can also create a funding mechanism whereby the government has funding to maybe deal with adaptation or lower the cost for customers that are seeing that price in the market. So that's more of a cap and invest type approach. The other more traditional carbon policy is just an emission limit or a performance standard, why EPA could do more of a command and control. So they could set a standard based on carbon capture and sequestration. They could say every unit has to meet that performance standard, and companies could decide how to meet that performance standard, but it would be an emission limit or technology-based performance standard, much more traditional command and control. For the energy sector, we're seeing a lot of states also have what are called renewable portfolio standards or clean energy standards. And that's where the government says for the power that's coming to the customers, it has some percent of it has to be from renewable or other clean energy sources. So that's another way to drive clean energy investment. There's also tools and incentives. So Congress recently passed a bill that I'll dig into shortly, whereby there's a lot of incentives and tax incentives, funding, grants. They're giving money to certain projects that Congress determined would help us in this clean energy transition. So that's much more of an incentive-based approach. And then we have corporations making net zero targets. They're deciding to buy certain renewable resources. That's much more of a voluntary decarbonization. But all of those in combination are on the table and possible. I'll talk about 2 court cases that I think are important to keep in mind that sort of set the basis for where we are in the process. And I know Vicki will get into more of this, but the first case to keep in mind is Massachusetts versus EPA. So this case was decided by the Supreme Court in 2006. And there, the court held that the Clean Air Act's term air pollutant can include greenhouse gas emissions. And the question was whether EPA has the statutory authority to regulate greenhouse gas emissions from new motor vehicles? And if so, whether they had to do that. And so the court first decided that the states could bring this case and that EPA has the authority to regulate emissions from new motor vehicles. And so the court didn't answer the question of how you have to regulate or whether you have to regulate, but they did say EPA had that authority. One thing to keep in mind that I think sort of setting the stage is that Justice Stevens wrote the opinion. Kennedy, Souter, Ginsburg, and Breyer joined that majority opinion. Chief Justice Roberts filed the dissent with Scalia, Thomas, and Alito. So if you think about who is on the court now, it's Roberts, Thomas, and Alito are the three justices of that first opinion in Massachusetts that are still on the court. I don't want to suggest that that means this court will overturn that decision. As I'll talk about, I think the bill that the Congress passed last summer reinforced the decision of this court that air pollutants are greenhouse gases are air pollutants that need to be regulated. But I think to keep in mind where the court is versus where it was in 2006 is important. The second case to mention is one that was out last year, West Virginia versus EPA. And there the question before the court was whether Congress authorized EPA to set a standard that accounts for the measures that reduce emissions from the electric system, and whether that can include generation shifting and a cap and trade program, and whether EPA's stated reasons, the standard limits measures that states can include in their compliance plan. And the court decided this question by finding that EPA could not set a standard that was an emission cap based on generation shifting. So that option is now off the table for the Biden administration. I think it's also interesting to note that Chief Justice Roberts talked about the role to clarify, and I included this language, it may be hard to read, but I think those slides are being posted, and that's that EPA has the primary role to set the pollution level reduction that's needed, and then states have the implementing role. So I'll talk about the rule the Biden administration is now working on, but I think it's important to recognize that the court did realize those two important roles in this process in the Clean Air Act. So quickly going back to Congress now, I know I'm jumping around, but this sets the stage for where EPA can go. As I mentioned before, Congress passed the Inflation Reduction Act last summer, and it follows a long history of trying to pass different carbon bills. Back in 2009, for example, the Waxman-Markey bill was trying to set an economy-wide cap and trade program, and that wasn't able to get through the House. But the Inflation Reduction Act was passed. It spurs investment through tax incentives, grants, and other funding mechanisms. And its sponsors estimate that the bill will drive an investment of nearly $369 billion in clean energy and climate priorities. And that in turn is projected to get to about 40% below 2005 levels by 2030. So if you think back to the graphic that Mike Gerrard had showed, 30% is what people were predicting we could achieve without any new policy. 40% the IRA is supposed to get us, and our commitment for the NDC by 2030 is 50 to 52%. So the IRA did move the needle. It's not getting us all the way, but it is, I think, going to be important. 2 points to keep in mind, as I had mentioned, the legislation also amended the Clean Air Act to make clear that greenhouse gases are pollutants. So it reaffirmed that Massachusetts versus EPA case, and it creates and it enhances the obligation for EPA to regulate greenhouse gas emissions from sources. Second, because of the incentives for clean energy technologies, a lot of EPA's regulatory authority often requires it to consider cost. So because the cost has really shifted for many of the technologies that are required to adjust and meet this transition to reduce greenhouse gases, it's really shifted the game pieces on the board that EPA had so that it dramatically reduced the cost, which allows EPA to consider a lot more options as it thinks through how do you regulate power plants, how do you regulate cars, and how do you regulate oil and gas sector, for example. Okay. So going back to the federal government, on the prior slide, I think it's important to dig in a little bit on the different executive branches that are regulating. So Environmental Protection Agency is critically important. They're implementing the Clean Air Act, the Clean Water Act, and a lot of the statutes that are going to have ways to actually require emission reductions from various sources. And I'll dig into 3 of those in a moment. But quickly, the Federal Energy Regulatory Commission, or FERC, that's an independent agency that regulates electric utilities. It regulates the interstates or cross-state lines transmission of electricity, natural gas, and oil. So to the extent we're building renewables in one part of the country and we want to move that power across the states, then FERC has a key role in that process and the permitting for that. Department of Energy, I often think of them as the technology experts in the federal government. They focus on spurring technology innovation through grants and loans. So they're implementing a lot of the IRA pieces that are grants and loans. They're also critically important to understand the technology advancements that are happening and make sure that those become commercially deployable. Department of Interior, they focus on federal lands. So to the extent we have lands that are promising for renewable development, they're a part of the permitting process for that. They're also focused on transmission lines that can cross federal lands. And then if you think about the third option, wildfire management, obviously for resilience and adaptation, they're involved in some of the mitigating the impacts of that as well. The last two I want to mention, the Inflation Reduction Act, as I mentioned, includes a lot of tax incentives. So the IRS is now in a process of developing the guidance for how those tax incentives can be captured, whether that's credits for electric vehicles or for carbon capture and sequestration and hydrogen, for example. I want to mention, and we can talk more about this, excuse me, in the Q&A is the Security Exchange Commission. So the SEC is in the process of developing rules about what corporations and how they need to disclose climate risks and how they're approaching those risks. Including their emissions plans and net zero targets. All right. So I'll spend the last few minutes talking about the power sector rules and three other sectors. So for the power sector, I want to flag the ELI summer school that happened, I think it was last week, where Jay Duffy really walked through the details of some of the greenhouse gas regulations that EPA is working on right now for the power sector. But I want to highlight 3 points about this rule. So first, it applies to existing gas plants, natural gas plants, existing coal plants, as well as new gas plants. And comments on this rule are due in early August, with a final rule expected next spring. And the general theme for all of those different components is that for the plants that are emitting the most and that run the most, they need to install the best system of emission reduction, which EPA is proposing is carbon capture and sequestration, or a very high level of co-firing with hydrogen. Importantly, though, this rule does not rely on generation shifting, which is what West Virginia versus EPA case rejected. One theme that I'll go through for each of the rules that I'm going to talk about, and I think it's important to flag here, is that EPA is trying to design the rule based on what's happening on the ground. It's a much more traditional command and control type of approach. But I think it's important to recognize that the energy sector is transitioning, independent of EPA's regulation, independent of the IRA. But the IRA really is accelerating that transition by giving incentives or carrots for companies to make the clean energy transition for the electric sector. And so EPA is working to finalize a rule that provides the regulatory certainty for that investment. And the debate that's really happening right now, as people are thinking about the comments, is what's the timing for that? And then also, it's separate from EPA's rule, but what's the infrastructure and what's the permitting process that we need to get all of this infrastructure built, whether that be transmission lines through FERC or permitting of different projects on the ground. So I think that's an important driver for what you're going to see in the comments and what you're going to see in the news. The second sector that's critical is the cars and vehicles. And so EPA has already finalized standards for model year 2026, and the comment period just closed for the proposals for model year 2027 and beyond. And Vicki will talk through the litigation that's happening on that first tranche, the model year through model year 2026. But I want to flag the same theme that we're seeing in the power sector. And here, EPA is trying to design a rule that's already building on what's happening from the auto manufacturers and the industry. Their most recent proposal from EPA is designed to achieve an emission standard for light, medium, and heavy-duty vehicles for model years 2027 to 2032. For the light and medium duty vehicles, EPA is projecting that under the proposed rule, EVs could account for as much as 67% of sales from light duty vehicles, maybe 46% for medium duty vehicles. For heavy duty vehicles, EPA is projecting that the proposed rule will account for between 25 to 50%, depending on the model year class. But what's interesting to note is that we're seeing a lot of announcements from the auto industry that are supportive of this transition and that are equally ambitious. And so again, the infrastructure is needed, the charging infrastructure is needed, the vehicles are going to be needed, but the IRA is, and as well as the bipartisan infrastructure bill that was passed earlier, is really starting to generate progress to build out that infrastructure that we're going to need. Lastly, methane from the oil and gas sector. So going back to the IRA, the Inflation Reduction Act that Congress passed, I had mentioned it includes a lot of incentives. So one of those incentives is funding for methane detection. So the technology advancements are happening to try to better detect and understand where methane leaks are happening, and the IRA provides funding for that. They also require EPA to update its reporting program, given that we understand methane emissions better. We know they're higher than have been reported. EPA is now in a process, and they just released the proposal last week to update its inventory for the oil and gas sector. The other key component is that the IRA imposes a methane fee. So although most of the IRA is incentive-based and carrots, there is one stick that I think is important, which is the fee. And that's essentially a carbon tax. So for every metric ton of methane that's emitted from the oil and gas facilities, they have to pay a fee on that. Except there's an exception, or a couple of exceptions, but one that I think is important to understand is that if all states and companies are in compliance with the EPA regulation, which I'll explain, then the methane fee does not apply anymore. So normally you see with an EPA rule, some of industry supporting it, some industry opposing it. Here, I think it's going to be an interesting dynamic to see many of the companies are going to want a strong EPA rule, and they're going to want all states to comply with it. So EPA is working to finalize this rule this fall. It's part of the international negotiation with COP. And so that's really driving EPA's actions. And I think it's going to drive a lot of companies wanting to support it. So again, you see EPA having an opportunity to base a rule on the progress that we're seeing on the ground. All right. I have last two slides just to show what progress we're making. So this is a graph from Rhodium. It is so a modeler that goes out and does a lot of different modeling on federal policy. And just to ground you, the current IRA policy is the blue bars. And so that's what's on the books. They estimate the IRA gets us to about 32 to 42% emission reductions. The green bar is what happens. They're making certain assumptions about various federal policies, but depending on the assumption, you get between 38 to 48%. And the gray is the Paris Agreement. So reminder, that's 50 to 52% by 2030. So I think it's important to note that with even ambitious federal policies, it's getting us close, but not all the way there to what we've committed to under the Paris Agreement. This next slide keeps the IRA there. So again, 30 to 42% with the IRA. The joint action scenario is one that's adding in leading states and state policies. So if you add in the federal committing into the Paris Agreement. I think it shows that the federal government can do so much, but it's also relying on federal state governments to continue to make progress. And I know Mike and Vicki will talk about that in the coming slides. So I'll stop there. I really look forward to the Q&A. Sorry for my cough, and thanks so much.
No, thank you, Carrie. That was fantastic. And really appreciate that overview of the way the courts are interpreting the scope of executive agency. We've had a number of good questions on that very point. So I believe Vicki will guide us through some of this. Our next speaker is Vicki Patton. She is the General Counsel for the Environmental Defense Fund. You'll commonly hear it be referred as EDF. This is a leading NGO that has been instrumental in driving activity and working with corporations. How do we secure these landmark national and state protections to address climate and air pollution? She has participated in numerous climate and clean air cases, and she's going to take us through some of the case law and considerations back and forth between the roles of the states, federal authority, and some of the decisions that are coming out of the courts. So, Vicki, we're so glad you're here. Please take it away.
Lisa, it is wonderful to be here with you. Thank you so, so much. Just taking a step back for a moment. We've been talking about the tons, the concentrations, the impacts. That is what this is all about. Are we taking action, together, rolling up our sleeves together to meet this moment in addressing the climate crisis? And it's a race against time. We also need to be very, very focused on the fact that many of these sectors emit a number of harmful contaminants and pollutants. And so Carrie talked about the US inventory of climate pollutants. Those large, big pieces of the pie that Carrie showed, the power sector, the transportation sector, the industrial sector, they also are major sources of other very harmful contaminants, toxic air pollutants, smog-forming contaminants, lethal particulates. So power plant smokestacks discharge climate destabilizing pollution, CO2. They discharge mercury and other non-mercury metals. They release nitrogen oxides that form harmful particulates and smog and other contaminants. Tailpipe emissions from cars on the road, large diesel freight trucks, they discharge a whole host of different pollutants and contaminants. Petrochemicals, the oil and gas industry discharges not just methane, which is a potent climate destabilizer. They also discharge, cancer-causing benzene and other contaminants. And so as we think about solutions, as we work together to try to figure out what solutions make sense and how do we design policies that are smart and thoughtful, a big part of that is ensuring that we are protecting communities. We've got to protect the climate, and we've got to protect the communities that are being afflicted by the whole array of harmful contaminants. And so it's not enough to be addressing climate change. We also need to be addressing the other air pollutants that cause enormous health harms to people and communities. Carrie really set the foundation for the Inflation Reduction Act, and it is hard to overstate how important that new law is to the work that we all do. If you do anything over the next few days as you're thinking about climate and justice and health and how our country is moving forward, spend time on the Inflation Reduction Act. There is so much there. It is, it's a 10-year investment. So for many, many years, our country has had investments that are for a year or two here and advancing in new clean technologies and clean solutions, a little bit over there, a little bit here. This is a sustained 10-year investment in clean, zero-emitting solutions that provides just an enormous opportunity. And just to really amplify what Carrie said, it does it in a number of different ways when it changes fundamentally the cost structure of clean solutions. And that really just happened. It happened instantly with the stroke of a pen when President Biden signed that historic law. The cost structure changed, and when the cost structure changes, that unlocks enormous opportunity for the private sector to invest, and to invest big and bold in these clean solutions. And much of this is all being implemented through the Department of Treasury and the IRS through tax credits. And so it's moving forward with great urgency and intensity. And then, as Carrie indicated, because the Environmental Protection Agency, when it's establishing pollution standards, those pollution standards are required by law to consider costs. When the cost structure just fundamentally changes and is driven down for clean solutions, it enables the Environmental Protection Agency in carrying out its Clean Air Act responsibilities to recognize that the clean solutions are much, much cheaper. And that enables greater ambition. In addition, the Inflation Reduction Act made a number of changes to the Clean Air Act itself. I started working at the Environmental Protection Agency in 1990 at the time of the 1990 Clean Air Act amendments. And the Inflation Reduction Act contains the most significant amendments to the Clean Air Act since 1990, reinforcing EPA's authority to address greenhouse gas pollution, making significant changes that recognize that zero-emitting vehicles are an important part of the Clean Air Act and the solutions going forward, reinforcing EPA's responsibility to address climate pollution from the power sector. And importantly, it also provides significant investments for communities and justice. And so there are multi-billion-dollar investments in community solar. There are billions of dollars of investments in community-based grants to address climate change and resilience and justice. That should be driven by statute, should reflect the views and perspectives and be shaped by the communities. Historic revamping of monitoring. If we don't know where pollution is happening, we can't have smart, thoughtful policies to address it. The Inflation Reduction Act has a whole host of programs that really change fundamentally and strengthen the extent to which we are improving our monitoring in our country. I've dropped into the chat two items. One is a terrific article that was published by the Environmental Law Institute's Environmental Law Reporter by a couple of key staffers who were deeply involved in shaping and working on the Inflation Reduction Act. And it's a terrific article that examines these statutory changes to the Clean Air Act and what they mean and why they're important and significant. I've also included a white paper that Environmental Defense Fund issued on the day that the Inflation Reduction Act was signed into law, really examining the ways in which the Clean Air Act is significantly changed by this historic new law. One final point about the Inflation Reduction Act: it changes the practice of law. We need you. We need all of you to be part of this moment, and the Inflation Reduction Act makes that clear. With these historic changes, there are enormous opportunities in thinking about tax law and how do you work with clients to unlock the full potential of the Inflation Reduction Act to ensure that their projects qualify for these clean energy and clean vehicle tax credits, to ensure that they're compliant with those tax credits going forward as they carry out the project. Tremendous opportunities in thinking about how do we build clean solutions at scale with great urgency with these historic investments. There are investments that are translating into manufacturing in communities all across the country, and billions and billions of dollars of investments right now, tens and thousands of new jobs, and they're happening in Tennessee and Kentucky and Georgia and Texas and Nevada and Michigan and Ohio and New York, all across our country, historic investments, and figuring out how do we site new factories, how do we site new transmissions so we can bring clean energy and clean solutions at scale, and respect the communities who are going to be impacted so that they gain in shared prosperity, and we are not perpetuating past injustices. This is important work. And really, with the Inflation Reduction Act, there is a tremendous new frontier for climate law, climate justice, and I just urge all of you to think about this if this is not your career already. And thinking about sort of the litigation, just want to touch on and spotlight some of the litigation that we're looking at in the fall as we pivot to the fall. And we'll touch on Supreme Court litigation, some Court of Appeals litigation. One of the big Supreme Court cases that we're looking at as we look over the horizon for the fall is Loper Bright Enterprises versus Raimondo. And in that case, some fishing vessel interests are challenging a program administered by the National Marine Fisheries Service under the Magnuson-Stevens Act that requires the vessel owners to pay for federal monitors that ensure compliance with our national fisheries standards, things like ensuring that the catch is consistent with those important protections for sustainable fisheries. There were two questions that were presented by the petitioners, and the court granted on the second question. And that second question is pretty stark. The second question reads, should the Supreme Court overturn Chevron versus EPA? And that's the question that the court granted on. The parties are going to be filing the petitioners their opening brief now on July 17th. The court just granted an adjustment to the schedule. The respondents, including the Solicitor General's office, will be filing their responsive briefs on September 15th. There will be lots of amicus briefs and lots of interest in this case. And when you think about West Virginia versus EPA that Carrie talked about, and the student loan decision, those are cases where there is a new judge-made doctrine that is changing the standard of review for what the court calls extraordinary cases. And there's a lot we have to unpack as a society, and ensuring that it is truly only extraordinary cases, and a lot to be determined over the next several years to ensure that is truly the case. This case, then, you might think about as what is the standard of review for agency decision-making for federal agencies that are entrusted with administering our laws in ordinary cases. And there'll be a lot of attention on this case, and it's Loper Bright Enterprises versus Raimondo, and will be likely argued in the court's November term. So keep an eye on that. And then a couple of cases that will be argued in September that are really important. As Carrie mentioned, the Environmental Protection Agency finalized really important limits on the greenhouse gas emissions from new motor vehicles that apply through model year 2026. They also restored the preemption waiver for California that ensures that California and other states that adopt California's leading clean car, clean vehicle, clean truck standards can continue to lead to meet those state needs, to meet those community needs that are so important. It's part of the architecture, the federalism architecture of our Clean Act. And those cases will be argued on September 14th and 15th. And on the 14th, before the U.S. Court of Appeals for the D.C. Circuit, Texas will be trying to expand the major questions doctrine and misapplying it to EPA standards that address tailpipe pollution, motor vehicle pollution, and do so in a way that is consistent with our nation's vehicle standards for decades and decades across Republican and Democratic administrations alike. And nevertheless, Texas and a number of other Republican state attorneys general and some oil and gas interests are arguing that the court should apply a much higher standard of scrutiny under the major questions doctrine. So that will be up in the DC Circuit on September 14th. The same day, the DC Circuit will be hearing challenges from a number of different interests to our nation's fuel economy standards that also apply in a similar way, in a similar timetable, and are administered by the Department of Transportation. And then the next day, the court will hear argument in this really important question of federalism, and that is the role that California has had since 1967. This is adopted over 50 years ago overwhelmingly by Congress, overwhelmingly, to ensure that California, which had long been regulating tailpipe emissions when Congress was moving forward with the modern Clean Air Act, that California could continue to do so and continue to meet its really important needs in protecting the 40 million people that live in California. And then Congress expanded that in 1977 amendments to the Clean Air Act to ensure that other states could also benefit from those important safeguards and protections. And the Ohio Attorney General's office, joined with a number of other interests, is arguing that it is unconstitutional for California to have this authority and for EPA to administer this provision of the Clean Air Act in this way under the equal sovereignty doctrine. And that's the doctrine that Chief Justice Roberts relied on in severely constraining the Voting Rights Act in Shelby County. So those are two important cases to watch in the fall. And the reason they're in the DC Circuit, the U.S. Court of Appeals for the DC Circuit, is because the Clean Air Act does something somewhat unique. It says that whenever there is a challenge to, national emission standards or National Clean Air Act protections that are national in scope or have national effect, that those cases need to be heard in the U.S. Court of Appeals for the DC Circuit. Congress made that decision many years ago. They wrote it into the terms of the Clean Air Act. It's really important. It's really thoughtful, because what it does is it helps provide some stability on judicial review. And as a consequence, courts like the DC Circuit have developed a lot of expertise on the Clean Air Act and a number of other related administrative law doctrines. And then I'm just going to touch on a couple of other cases that are pending and a new important area of law where we may see some additional litigation, unfortunately. As you all know, climate change is an existential threat. It's an existential threat to the health and well-being of communities all across our country, all across the world. It also can, in a moment, destabilize our financial system. And we've seen that. We've lived through that with the brittle and disruption of the supply chains and how that rippled through and had enormous adverse economic consequences as we were dealing with a global pandemic and other really serious threats and impacts. For many, many years, there has been just an enormous amount of economic literature, financial literature, leadership in the private sector, recognizing that our country and financial systems and regulators across the world need to be ready for this. If we are not ready for the changes, the disruption that climate change will bring in managing our financial system, it's going to hurt everyone. And so the Department of Labor about a year ago adopted some standards under ERISA, the retirement program, that help ensure that asset managers for retirement assets that are long-term investments, if anything's going to be subject to to potential, uncertainty and disruption and harm from climate change. It's those retirement assets, and said that consistent with managing for, risk and return, consistent with, financial fundamentals, asset managers can consider a number of risks, including climate risk. And so it was just enabling the consideration of this in prudent decision-making on risk and return. That has been litigated. There's litigation pending in district court in Texas and in district court in Wisconsin. And the litigation in Texas has been filed in the Amarillo division, where when the challengers file, they have 100% chance of having the case assigned to Judge Kasmerick. So it's pending before Judge Kasmerick in the Amarillo division of Texas. And so we'll be watching sort of the outcomes in both of those cases, both in the District Court of Wisconsin and in Texas. And then we're anticipating this fall that the Securities and Exchange Commission, and as Carrie mentioned, it's an independent body, an independent commission, will take a number of actions related to addressing the intersection of financial risk and climate risk, and they are intertwined. And that is to provide clarity that I think helps provide greater transparency and accountability for ESG funds and fund management by making sure names are not deceptive and that there's some standards around that and better disclosures. And then a second set of rules that will provide for publicly traded companies to better disclose how they are managing and facing climate risks, so that investors from Main Street to Wall Street have sound information and where they put their money and how they invest. And so those important regulatory actions will likely be adopted sometime this fall. And then the other area we're just watching for is whether there might be some litigation over the administration of some of the tax credits in the Inflation Reduction Act. I hope not. I think it could be really disruptive, but it's not out of the question that there will be. And a couple of areas that have engendered a lot of conversation, a lot of attention include the Department of Treasury's efforts, which are in progress to administer the hydrogen tax credit under 45V, and the tax credit for personal vehicles under 30D. That's also engendered a lot of attention. So a lot to watch this fall, and as the litigation landscape moves forward. And thank you so much, Lisa, again for the opportunity to be here with you. Appreciate it.
What a fantastic presentation and overview. And yeah, there is so much I want to ask all of you, and I'm delighted that we have a good amount of time. Again, on the screen here is that screenshot of the climate litigation database supported by the Sabin Center, founded by the Sabin Center. Incredible resource to get access to some of the cases that were mentioned. Thank you to Grace and Madison for putting some links in the chat. Hopefully we will have access to that. To some of those links. You'll have access to the slides, but there is so much great information here, and you all, thank you for all your great questions placed in the Q&A. For the sake of time, and so we can give our panelists a good opportunity, forgive me, I'm going to mush some of these questions together and try to sort of glean a few themes that have come across in each of these presentations. I'm going to start last, work my way back up, because Vicki, thank you so much for really taking us through where we are, how these different questions about executive agency action are coming to the fore. Oh, my goodness. Thank you, Sarah. I am sorry, Michael, I forgot about your additional slides on climate litigation. Please continue, and I will hold my questions till after you are finished.
Okay, thanks very much. So let me again see if I can control the slides. And so, as Lisa said, this is the Sabin Center has a database that tries to capture all of the climate change litigation in the world. I'll put the link in the chat, but it's climatecasechart.com. And let's see, am I controlling the slides yet?
Yes, you should be able to, Michael, just click the center of the screen and it'll take over. There you go.
Got it. Okay. So the total number of cases around the world has been expanding. Climate change litigation really took off around 2007. But there's a great deal of it. And here the cases in red are in the US and the cases in blue are in other countries. A snapshot, a few snapshots in March 2017, we had counted 884 cases. It's now up to 2180 as of December. Today is probably about 2,300. We have cases now in 65 jurisdictions, 65 countries and other tribunals, and about 70% of all the cases are in the US. The cases outside the US that have large countries with large numbers of cases are Australia, UK, and so forth, but the US is by far the champion, if you want to call it that. In the US, the largest number of cases are under NEPA, and also a very large number under the state equivalents of NEPA, especially California. These are basically cases saying that the environmental impact review of a number of activities and projects did not adequately look at climate change. We have a lot of cases under the Clean Air Act, which Vicky and Carrie have talked about, under the Endangered Species Act, and under various other statutes. One line of cases that I just want to spend a few minutes on, the most prominent case was called American Electric Power versus Connecticut. Connecticut sued and several other states sued several power companies, asking the court to issue an injunction to require them to burn less coal to have lower greenhouse gas emissions. The primary theory was under the federal common law of nuisance. The Supreme Court, in a decision by Justice Ginsburg, said no, that the Clean Air Act had given EPA the authority to regulate air pollution. The 2007 Massachusetts decision said that that applies to greenhouse gases, and therefore it's really EPA's job to set the reasonable levels of greenhouse gas emissions. It was not a role for the federal common law of nuisance. The federal common law of nuisance deals with filling gaps in interstate disputes, and there was no gap remaining. This was seeking an injunction. There was another case seeking money damages brought by a village in Alaska that was being damaged by the melting of the sea ice. They sued a bunch of fossil fuel companies. The Ninth Circuit said that the same doctrine applied to money damages cases. But these lawsuits were brought under the federal common law of nuisance, and the courts left open the question of whether the state common law of nuisance might apply. So beginning in 2017, we saw a whole slew of cases brought mostly by counties and cities and then states against fossil fuel companies seeking money damages for the cost of adaptation, the cost of building seawalls and other things to prepare for the climate change that is coming. Almost all these cases were held up on the question of whether they belonged in federal court or state court. The plaintiffs all wanted them to be in state court. The plaintiffs wanted, the defendant fossil fuel companies wanted them to be in federal court. It bounced up and back and up and back. Finally, a couple of months ago, the Supreme Court said that they can stay in state court for now. So these cases are going to move forward in some fashion, and we see that these are cases mostly brought along the coasts, except for Minnesota and Boulder, Colorado. A new case was just filed about a month ago by a county in Oregon. So these are continuing. One of the cases where initially brought in federal court, and so didn't face this federal state jurisdictional issue. And there, the Second Circuit dismissed the case, saying that this is really a federal case, and federal law federal common law is preempted, and therefore these cases can't go forward. But this issue is going to be litigated in these other cases. We're already seeing some motions to dismiss on the argument that a state court really shouldn't have control over what happens outside of the state, doesn't have jurisdiction over some of these entities. Then we're going to see substantive motions to dismiss. We'll see a lot of discovery demands and motions. So I think this is going to be a very active area of litigation for the next several years. Let me just skip these. And another round of completely different line of cases was really inspired by Professor Joseph Sachs of the Michigan and then Berkeley Law Schools, who in 1970 wrote an important article about the public trust doctrine, which is something going back to the Justinian Code, but basically saying the government has an obligation to protect such resources as forests and rivers. Professor Mary Wood of the University of Oregon Law School then began arguing that the public trust doctrine applies to the atmosphere and gives governments an obligation to protect the atmosphere from dangerous climate change. A group formed in Oregon called Our Children's Trust, an NGO that has brought a large number of lawsuits around the country based on those theories. Most of those cases were dismissed. Most were brought in state court, and they were dismissed on various grounds until we got to the very famous Juliana case in Oregon, brought in the Federal District Court of Oregon by 21 young people against the federal government, asking the court to order the federal government to prepare and implement a national remedial plan to phase out fossil fuels. This case bounced up and down again. The district court denied the motions to dismiss, set a trial date. The Department of Justice under the Trump administration tried to get rid of it in various ways. And ultimately, the Ninth Circuit issued a ruling in January 2020. The two members of the majority basically agreed with the plaintiffs on their scientific allegations, their allegations about dangers caused by climate change, but they said it's not the job of the courts to solve this, that it should be done by the political branches, by the president and Congress. There was a dissenting decision that said essentially that in view of the existential crisis that we're facing as a result of climate change, the courts should act. But the majority dismissed the case. The plaintiffs then went back to the district court with a request to amend their complaint to ask not for a binding order that the federal government come up with and implement a plan, but just a declaration of rights. They argued this case in June 2021, and last month the trial court granted the motion leave to amend. The Department of Justice now under President Biden has opposed this motion and has said that if the district court doesn't dismiss the case, they want to go up to the Ninth Circuit. So we'll see what happens with that. Finally, Our Children's Trust and local council in Montana brought an important case called Held versus Montana under the Montana State Constitution. The Montana State Constitution has an environmental rights provision, and the plaintiffs, again, a group of 16 young people, sued the state saying that their pro-fossil policies violate the state constitution. This case actually went to trial last month. There were 7 days of trial. The plaintiffs put on the youth plaintiffs who indicated the injuries they had suffered, put on several scientists, mostly from Montana, to show how climate change is hurting the state. The state of Montana had said that they were going to put forth a scientific witness. They withdrew her at the last minute, and their basic defense was that the emissions from Montana are so low that it would not be fair to impose obligations on Montana to reduce their emissions, since their state emissions are such a small portion of the national picture. So right now, the plaintiffs and defendants are writing their post-trial briefs, and we're looking for the decision, which might come out next month. We shall see. This is only the third case on climate change that has actually gone to trial in the United States, and it'll be interesting to see what happens. So I'll end it there.
Great. Thank you, Michael. And yeah, there's not too much there's so much that can be said about, again, the over 2,500 cases globally that are being tried before the courts on a number of different issues of rights and responsibilities. And so again, we're so grateful for the work of the Sabin Center in shaping and providing that resource and making it publicly accessible. Again, I want to thank you all for your very good questions. I have tried to sort of summarize and condense them down a little bit, not in any order of importance, but I do want to pull out those questions where each of you touched upon different aspects. And Vicki and Carrie, you both talked about the major questions doctrine in the context of what is the scope of executive agency and how important the actions of EPA have been in developing regulatory regimes to move us in the right direction. I think there are concerns that how do we preserve the various programs that will be and have been not only important in reducing those emissions, but also creating those very important market signals. So just a little bit of, for each of you, I'm going to, again, we'll start with the order you spoke, Michael, Carrie, then Vicki. I would love to hear a little bit about your thoughts about the major questions doctrine in ability to meet this race for emission reductions, and whether or not you think SCOTUS has, just your takeaways. I don't want to put words in anyone's mouth or unduly influence answers, but would love to hear from each of you the major questions doctrine and the role it could play in our ability to meet climate emission reductions.
I think it's a very dangerous doctrine that enables the courts to intervene in a wide variety of areas where they don't like what the government is doing. There are no clear standards for what would be a major question. There are no clear standards for when the government goes too far. We're already seeing the major questions doctrine popping up in all kinds of lawsuits against all kinds of programs. It really is, in my personal view, the Supreme Court stepping seriously over the powers of Congress and the executive. And I think that with this court, it is opening lots of possibilities for actions that will stand in the way of action on climate change and environmental issues and public health issues and lots of other areas.
Yeah, I would agree. It's why I go back to sort of the three branches of government. Each of those have a role and there is a purpose, and Congress is supposed to create the statutes. The White House has the authority to decide what its policy priorities are, and they get the agencies to have that expertise to design the rules that implement what Congress has designed. And then the courts should be deciding if the agencies are following Congress, not deciding these policy decisions. I think they are taking on a role with the major questions doctrine that's putting them much more in a policy decision-making process, not just deciding if what the agency's expertise had done. And I think the agency process, this rulemaking process, should bring in all this expertise. What are companies doing? What are the technology advancements? What's the cost information? What's the statute that Congress said should be happening by the agency? So is the rule protecting public health and welfare? Is it the best system of emission reduction? Those are statutory textual arguments that I thought that's what I learned in law school from all these experts. That's what you should be doing, not just deciding, is this a policy priority? And this is a big question, and that's not a legal doctrine.
Yeah, I think it's a profound threat to the ability of our country to achieve our science-based climate goals, and at a time, paradoxically, when the costs of these solutions are cheaper. The costs of clean solutions are creating jobs and economic prosperity. And we have a real shot at a better, brighter future. If you are a conservative, this flies in the face of everything. It is not anchored in originalism. And there's just a terrific Columbia Law Review article just refuting this and really digging in deeply. It's not anchored in textualism. It's an affront to the text of the statute, as we saw in the West Virginia case and the student loan case, and it is not anchored in judicial restraint. It is, and I would add, it's I think deeply anti-democratic when we enact legislation after lots and lots of difficult debate and careful thinking, and it gets forged into law. We do that and through a very, very difficult democratic process. And then there are, Senate confirmed agency heads who go through Senate confirmation and are scrutinized and are subject to lots of oversight, who are entrusted with administering those statutes consistent with the way that Congress wrote the law. And then to have just an opaque doctrine that can disrupt or be superimposed at any time with really no clear standards. It is just an affront to judicial review in a democracy.
Yes, I happen to share those, but this is not my platform. So we'll go to the next question. So all of you also spoke to this question that we are in a race for time. And there have been some interesting questions that have come up in the chat about, what is the appropriate role of oil and gas in these discussions. There's a lot of controversy in the upcoming COP. We have a former leader of an oil company that will be the president of the next set of negotiations this fall. We have had questions of conflicts of interest in terms of to what extent are they part of the discussion? Do they need to be part of the discussion? Are they undermining our ambition? And there are ways in which, even at the shareholder level, we've looked at questions of whether or not major shareholders like CalSTRS and CalPERS, should they be divesting from fossil fuel in their own assets, or should they continue to hold those assets and engage in those discussions with oil and gas companies? So I'd love to hear from each of you. Where do you see the sort of moral line in terms of where do we collaborate? How do we collaborate with oil and gas interests without compromising the goals and ambitions of reducing emissions as quickly and effectively as possible? Same order. Michael, you first.
Well, there's no question the principal task in reducing greenhouse gas emissions is to transition as quickly as possible away from fossil fuels toward cleaner sources of energy and energy efficiency. And I think that has to be tackled on both the supply side and the demand side. We need to be reducing the production of fossil fuels. The International Energy Agency has said that in order to meet our climate goals and stay at 1.5 degrees, but also meet basic energy demands, we don't need any new oil and gas exploration. The oil fields and gas fields we have are plenty. There shouldn't be any more exploration, but we also need to drastically reduce demand. The principal demand for oil is transportation, so we need to be moving to electric vehicles. Eventually, if we can, we need to densify our cities and so forth to do various things to reduce travel. We need more energy efficiency. So I think all of these are very much necessary, and anything that stands in the way of either of those should be resisted.
Yeah, I would add it is hard. We know where we need to go, and there is a push and a pull that has to happen. I think you don't just get to jump to where you are, though. I think you have to deal with the supply and the demand. I think because it is so hard, and it is not just the US, it's thinking about all the other countries as well, and what are their politics and their demands and their development needs. I think it's a matter of working with all parties. So working with the NGOs and communities, working with industry. Before my position here, I worked with the power sector, many of the companies that were in the West Virginia case supporting EPA, and I think their voice is critical to explain to this court why they can support that rule and why they think that rule made sense. So I think there are opportunities to leverage all those different voices, because in the end, that's going to make the rule most durable is if it's robust, technically sound, and addressing the environmental issue. But it is messy and it is hard.
I would just add to the thoughts that we need to address the climate crisis with great urgency, and we need all solutions, all of the tools in the toolbox, and all of the voices and concerns. It's all an important part of the discussion. I do think that when the oil companies make public commitments that they do not keep, and there have been a number recently of really high profile commitments where there were a number of oil companies that said they had made commitments to decarbonization, to a climate transition by specific dates, and they walked away from those and adjusted those, that they should expect more scrutiny and more pushback and more pressure from all of civil society, in a way that is thoughtful and high impact, because we need to make the transition with great focus and urgency.
And I agree. I also feel like I would be remiss if I didn't take this opportunity to address, clearly we're at a place where urgency is needed. Michael, you touched upon the difference between 1.5 as a negotiating point in the global discussions, particularly led by the small island states. But given that we have hit 1.5 and that we have a number of challenges, although also opportunities, the IRA is a very huge and good step in the right direction in meeting our targets by 2030. There is this question, though, of where we have urgency, how do we make sure that we do not worsen many of the disparities? Those who are least responsible for climate harms are at risk of bearing the burden disproportionately. We talked a little bit about market-based solutions in this discussion, a little bit about the clean development mechanism, a little bit about some of the tax incentives and market signals. I was just wondering, for each of you, what do you think can get us to these? What would you like to see if you had a magic wand? And this is in connection to a question we had, is what if we could go back to 1992, which we cannot do, but where we are now, what, if anything, do you believe can get us to our ambitions And the whole context, what should a court look like, what the states look like, how can we support those efforts to get us where we need to go as quickly as possible without worsening the harms that are already manifesting themselves.
You have a couple hours?
No, we only have a couple of minutes, but go ahead.
Let me start by saying, although there have been some places that have reached or exceeded 1.5 degrees, we're not yet at the global mean of 1.5 degrees. I think we're at about 1.3. We're going to get there, but I don't think the global mean isn't there yet. I think that the single factor that is most inhibiting strong climate action in the United States is the partisan division and the fact that one party stands in the way of everything that is sought to be done. And they're going after companies that are trying to do the right thing. There's this anti-ESG movement. There are efforts to try to repeal these laws. The red states are repealing a lot of these things. When a young person asks me what can they personally do that would have the greatest impact on climate change, which I guess get asked all the time, my answer is go to a swing state and engage in voter registration and get out the vote efforts. I think that's what would have more effect than anything else. I think we're seeing tremendous technological developments, as was alluded to. The cost of wind and solar has plummeted. We're seeing a lot of technological solutions that are coming forward, but they're not happening nearly enough. And I don't think we're going to have adequate action until we have a change in the politics. And it's not only the US. I mean, the reason why the Paris Agreement is as weak as it is and all the other agreements is that they all depend on the domestic politics of the countries. And so each country has to, the politics in each country fundamentally determine what the international agreements look like. But most of us on this call are Americans, and we can have hopefully an influence on U.S. politics, and we're just all to try to do that.
Yeah, I would agree on politics and votes as the key piece that drives who's in the White House and who's putting justices on the Supreme Court. And that changes it. I would add, I think the other piece, especially for people thinking about careers, is go into the government, because the government relies on experts being in there, whether you're a scientist, a lawyer, a technology expert. That is critical to make these rules, to be able to have the government agencies get the information that they need to then make the rules that then get through the courts. So I would just add that to the politics as well.
Yeah. The polarization, has delayed just an enormous amount of progress. And it's been, manifested in just lots of different ways of that there's been obstructionism to progress. And so the massive litigation over every action, no matter how sound, how sensible, how anchored in statutory authority, the really effort to deny that climate change exists at all, and just it's really deeply polarized our country. And on Monday, a group of climate denialists who have been doing that work of climate denialism and obstructionism for a long time filed a rehearing petition in the DC Circuit, asking, trying to overturn a 3-judge panel decision that effectively, upheld EPA's foundational endangerment finding that 6 greenhouse gases harm human health and well-being, and that's filed at a time when people are literally suffocating, and they're suffocating in Canadian wildfire smoke that is reaching all across our country, and heat. This is, and it's the most vulnerable in our society who will bear just really, really serious impacts. There is just a tremendous opportunity to engage. We have a place for everyone, to work on these issues, whatever your perspective, whatever your background, whether you're a scientist, an engineer, a grassroots organizer, a legal expert, there is a place for you to work on these issues. We need to, have transactions that enable clean energy at scale. We need transmission so we can, bring clean energy to population centers. There is a space for everyone to work on these issues, and it could, this is the time, and we need you and we want you. And so, let's all work together. Let's just decide let's just do all we can to end the polarization and grow the number of people, all perspectives, all backgrounds, all zip codes who are working on these issues.
I'm so glad you said that, because I firmly believe, and I appreciate Nicole Cook's comment, communications folks. If law is not your passion, it need not be. We just happen to be very fortunate to have some great legal experts. Last round of questions, just because we have a little bit of time left. I would love to hear a recommendation from each of you that you think our audience would benefit, either a book, a website, or a podcast that you think might help inspire and enjoy and sort of inspire folks to action on climate. Michael.
So Elizabeth Colbert has been a wonderful writer and journalist on these issues for many years. So any of her several books on the subject, I think, are very important. A journalist named Jeff Goodell wrote a book several years ago called "The Water Will Come," and he just a couple of days ago issued a book called, I think, "The Heat Will Kill You First," about heat waves. And so I think that there's too little attention being devoted to how do we cope with the impacts of climate change, since we know we're seeing a lot of impacts today and they're going to get a lot worse. So I think focus on dealing with the impacts also deserves a lot of attention.
Oh, those are good ones. I was going to say NPR had Jeff Goodell on describing his new book. So I love all those suggestions. Go ahead, Carrie. Sorry to cut you off.
I'm just picking one. I would say for this topic, I would recommend Richard Lazarus's Making Environmental Law, or The Rule of Five. He just did a second edition of Making Environmental Law, and it really provides a history of how far we've come, which gives you optimism, but then also explains the challenges that are there. And he writes really well for non-lawyers to read. So I'd encourage that book.
Yeah, there's so many really terrific resources out there. One podcast that's really fun and interesting and gets into the weeds on a whole bunch of topical issues is Dave Roberts' podcast, Dr. Volts, and it's he really, and he's pretty fearless in asking tough questions and really grappling with a lot of the issues of the day. And whether you agree with his perspective or not, there's just a ton of information. And I would love other folks' thoughts about what they find helpful. I'm really interested in other ideas about books that have been helpful, articles, podcasts. Please send them along.
Yeah, definitely. I have to say, I will add the America Adapts podcast. I've had a lot of great speakers and practitioners, and just because there's not as much talk and need about adaptation, I particularly enjoy that one for the experts that it's had. Many of them are your colleagues, actually. And there are a lot of great suggestions and recommendations in the chat as well. So Madison, I don't know if this is a good time to sort of wrap things up. And again, thank you so much to each of you for your time and your insights. And I know I learned so much to this, a lot of good cases to be watching out for. It's challenging to stay on top of all of those particular cases and where they are in the pipeline of decision making. So thank you for that. Thank you for ELI for having this, for having summer school, because and for having climate change on the agenda. So with that, I'll pass it back to you, Madison. Thank you.
Thank you so much to Lisa and Michael. Carrie and Vicky for speaking in today's program. We so appreciate your time and energy preparing for this program and your time answering all of our audience questions, as many as we could get to. Climate change is such an important issue, as you've all highlighted so well, and we're so grateful that you took the time out of your busy schedules to educate our audience about it. To our audience, please join us back at 12 o'clock Eastern next Thursday for our last webinar of summer school, which will be about environmental justice. 2 weeks from today, we will also be hosting our last in-person session of summer school and the last session of summer school for 2023, which will be at ELI's office, and we'll be discussing hazardous waste in sites. If you can't make it in DC, we'll also, of course, be posting the recording online, as we have been for all of our summer school sessions, so you can find those all on ELI's website or on ELI's YouTube page. Please remember to register on eli.org if you would like to attend the last 2 sessions. Just thank you so much to all of you. So appreciate your time, and I hope you have a great day. Thank you.